topics and opinions expressed in the following show are solely those of the host and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert Show on W4CY Radio and Talk4 TV, where we bring you educational information from experts on such topics as legal, health, financial, and home improvement. Now sit back and listen to our experts in community association law, estate planning law, tax relief, Medicare, public insurance adjusters, neuropathy treatment, business brokers, and personal injury law, along with many other topics. Now here's your host for the last 17 years, Steve O.
South Florida, welcome to another Ask the Expert show, where we bring you the finest experts in the field of legal, health, financial, and home improvement. Hey, this is the first Thursday of the month, and that means K. Bender Rimbaum. And I got to ask my buddy, he's a senior partner of K. Bender Rimbaum, attorney Robert K. Did you notice our new opening? Who comes first?
I did not, I'm afraid to report.
Because it's always been the same for the last 12 years. Now it's we do community association law first.
Oh, nice.
Anyway, good afternoon, Robert.
Good afternoon to you and everybody listening.
I got to tell you, this is kind of a little bit behind the scenes. Our show is only for 50 minutes. We never get all the questions in, ever. And here I am asking TikTok people to write their questions in. This show is our number one show. This show gets more likes, more views than any of our other shows. This show has been with us. This expert has been with us longer than any of our other experts. Robert, I got to tell you, I love doing this show with you. People just write letters that don't even have questions, just thanking for the time that you put in to do this show every month.
Well, I'm happy to be here. It's great fun for everybody.
Exactly. So we've got all these new people. If you don't mind, tell people about K. Bender Rimbaum.
All right, quickly, K. Bender Rimbaum is a law firm that focuses on representation of community associations. We're made up of a large portion of the board certified community association specialists in Florida, identified by the Florida Bar. We have I believe 11 attorneys that currently hold that designation from the Florida Bar, and that's out of roughly 200 throughout the state. We provide all aspects of legal representation to community associations, be it reviewing the governing documents, providing opinions as to the rights and responsibilities of the association and the owners, undertaking negotiations, contract negotiations, dealing with city issues, county issues, pursuing unpaid assessments that might come up from time to time for associations, dealing with construction defects, pursuing, if necessary, litigation in that regard for responsible parties that may have failed to perform contracts with the association. Anything that the board runs across on a day-to-day basis of a legal nature is something that we provide. And as you indicated, we have 4 offices in Florida, the main office in Pompano Beach, Palm Beach Gardens, Orlando, and Tampa.
Again, we're here with attorney Robert K. of K. Bender Rimbaum. We're talking about community association law today. Hey, we've already got our first question coming in from the chat line. Please clarify HB 803 and how it changes any procedures for a condominium association.
What I know of HB 803, it involves building permits, and it changes the statutory limit for when a building permit is going to be required. It had been 2,500. It's up to 7,500 now. Did not see anything specific as it relates to condominium associations, but I have not at this point spent a lot of time analyzing that particular statute. It's brand new.
Has it been signed?
Yes, that's in effect as of July 1.
Because sometimes our listeners are way ahead. You know,
we're into July now, and everything that was going to be either has been or has been vetoed. So
very good. So someone just asked, how long has your firm been around?
The firm was founded in the beginning of 1992. I've been providing these services continuously since that time.
Wow. Well, you should be very proud of what you've done with K. Bender.
I am.
And we're going to be talking about, you got a busy month in July.
We'll be talking
about dates and times, and so get your pencils out. Let's start with Cooper in Delray Beach. When our board of director members go north and we don't have board meetings, how do we get the okay to pay for an irrigation repair that needs to be done?
Well, just because board members are not physically in Florida doesn't mean they can't have meetings. These days, a large portion of board meetings are being done through electronic means such as Zooms, and the board members don't have to physically be here to be present. They can also be by telephone. All you need is a quorum present and the ability of the owners to be able to participate and hear everything that's going on. With a Zoom, you're required to have a physical location in Florida that owners can go to if they don't want to use Zoom. But if the board's not inclined to do that, there are options that it could consider. You can create an executive committee that's going to be local and give them limited authority to make decisions up to a certain dollar amount. Board members can discuss issues, and if they have emergency issues that have to be done, those can be ratified by the board at a later time when the board comes down and starts to convene meetings again. But just because the board's not physically here doesn't mean they cannot hold a meeting and take action. The other option available to the board is they can take action by written resolution that would be signed by 100% of the board members. So they can take that action and they can circulate the resolution to the various board members for signature. It can be an electronic signature, and that becomes part of the official records of the association. When you take action by written resolution, there's no requirement of holding a meeting.
You know, this is really odd. This has never happened before. We just got a question from our YouTube and one from our TikTok, two different people asking basically the same question. Wanting to know, can you clarify the difference between HOA and LOA?
LOA is not a term that I run across ever. I'm assuming that's a landowner association, but I've never seen that referenced before. But an HOA is a homeowner association. If it's supposed to be subject to Chapter 720 of Florida statutes dealing with residential property, that would be one form of HOA. But POAs, property owner association, HOAs are generally the same thing. And LOA is one that I don't think I've ever seen.
We've never had, and we had two people ask that.
That might be in another state.
Let's go to, could you discuss HOA educational requirements needed as of July 1st?
The HOA educational requirements for board members haven't changed this year from last year. So I don't think that's the best use of our time today. Whatever they have been, they're the same. So you have to get your continuing education as a HOA board member each year. And we do offer that. You'll hear some of the options that we have as we address them later on in the show.
Okay. This goes again. We're getting a lot of questions on YouTube. Does sales tax need to be collected and forwarded to the state if clubhouse rental fees are collected?
Well, I'm not a tax attorney, and I don't profess to know the ins and outs of sales tax requirements. That's a question that I would refer to the association's financial advisor.
Okay. Let's go to, we've got a lot of people writing questions in. Again, thank you for your question. Try to let us know if you're an HOA or a condo association. There are different rules. We're going to go to Dean in Miami. I really enjoy your show. What about an HOA that conducts a side venture such as an occasional community market to fund small committee expenses? Any problem with that? Detractors are saying we can't as we are a non-profit.
Well, first off, you're not a nonprofit. You're a not-for-profit, which is something different. Not-for-profit is a corporation in Florida under Chapter 617 of Florida statutes. Nonprofits are something different under the Internal Revenue Code and take certain requirements to qualify based upon the activities of the entity, which we don't really have to get into for you here. Being a not-for-profit corporation doesn't mean that you cannot have income that doesn't come from assessments. Many condominium associations have laundry leases. They don't own their own laundry equipment, and they get income from that. Many communities have little events that they do that they raise money with, and it could be taxable. So it's important that when the association has an income coming in that isn't from assessments, that they make sure that they make their financial tax consultant aware of it, be it their CPA or whoever is working with them on their annual tax return, so that they're aware that there is potential income that might be taxable. It might not be taxable if they use it all up for purposes that they're raising it for. Again, that's an issue for their tax consultant.
Ben in Palm Beach Gardens, is there any reason the board could not conduct a non-binding online survey of the owners? Since this would be a survey rather than an official vote, I assume a quorum would not be required.
I didn't quite hear all that question again.
Okay, this is there any reason the board could not conduct a non-binding online survey for the owners?
Oh, right. There's no legal reason why they can't do that. The board can communicate with the owners across a wide variety of issues. And many times we've had clients that want to get a feel for how the community, what opinions they may have on certain issues that fall to the board to make the decision. So they'll take an informal poll of whoever responds just to see if the community's feeling one way or the other on the issue. And so it's certainly, there's no legal issue in doing that. It doesn't bind the association. If 80% of the responders go one way and the board chooses to go another way, that's fine. They legally can do so. They might create a political problem for themselves within the community, but not a legal one.
This is 4th of July weekend, and we're getting a lot of people writing in about flags. I'll just take one of them. Why would a board not allow an American flag to fly on the 4th of July?
That's not a legal question.
That's up to the board, right?
Well, they're not allowed to do that under the law.
Okay.
I can't tell you why a board wouldn't want it.
Okay. Let me go to David. Can you ask about continuing education for condos?
I'd really rather not get into the ins and outs of education today. So I appreciate you asking these questions, TikTok people. Education is really not something that we want to spend time on this show with.
Okay. Let's go to our next question. This is about running for the board. I've been pondering about running for the board for several years now. What kind of background do I have to have? We get a lot of people asking that.
Typically, and unless the governing documents contain something specific, which I've never seen, the only requirement is you got to be over 18 years of age. You don't necessarily even have to be an owner in the community unless the documents, particularly the articles of incorporation, contain such a requirement. What requirements that an individual has, it can tend to be more of a political issue than a legal one when the election time comes around and the owners are considering between their various candidates. We've seen sometimes in the past that people that have extensive backgrounds in business and accounting and engineering can be helpful, but sometimes that gets in the way. They don't necessarily engage with the experts in the industry. And from Florida, where they have these expertise from other states, and sometimes that can be problematic. It doesn't hurt to have that if they're using the experts that the association engage. It might cause problems if they just try and take charge and do it themselves. What's necessary and helpful is that there be a sufficient amount of time to commit to the association, to attend meetings and to become familiar with the issues that the board is dealing with, to be prepared and to be willing and able to vote on issues and make decisions. We've seen many instances in our clients where board members just won't make a decision. And that's really their primary job, is to decide on the issues that come before the association. Obviously, that they shouldn't be making decisions based on their own personal interest. It should be from a perspective of the community as a whole. And so there is a fiduciary deadline, or a fiduciary obligation, sorry. I was reading one of the comments. There's a fiduciary duty to the association by the individual board members, which is a higher level of care and making decisions than there would be for just the average unit owner. But there is no specific requirement in the law for any particular background.
Okay. Jack and Boynton, our HOA is considering adding amenities, i.e. pickleball courts, playground equipment. Should they increase or change type, amount of liability insurance coverage?
Well, definitely by putting in things that people will be doing physical activities on, which increases the possibility of an injury on the association property, you're going to want to consult with your insurance provider to make sure that the coverage that is in place will be sufficient for the added risk that is being developed by these changes that are being made within the community. So definitely there's the need for that consultation. Now, the policies in place may have sufficient coverage, but you're going to want to get that information from your insurance provider. And if you can get it in writing, it's preferred.
John and Davey, having the board in a group chat giving directives to the property manager Is that constituted a board meeting?
Tell me the situation again.
Uh, our HOA is considering adding amenities like pickleball courts,
Well, that was the
playground.
last question.
Okay. Sorry. Oh, in a condo association, can a unit owner or board member run a business from his or her unit?
Okay. That's going to depend on the documents. Quite often, the documents will provide a prohibition of commercial activities from within the units. Often it's silent. It doesn't have anything about it. When it's silent, there's a presumption that the owners can use the unit for any legal purpose that doesn't conflict with the documents. So that would be something that can be done. If there's going to be a business run, many communities put in limitations so that it would be something that isn't going to be intrusive on the quiet enjoyment of the other residents, that there's not going to be constant people coming in and out, that there's not a significant amount of deliveries of materials or various supplies, and that there isn't noise that emanates from it. Certain types of commercial activity, like somebody's working as an accountant from his unit, is not going to bother anybody, and nobody's likely to even be aware of it. But again, the declaration of condominium has to be consulted to make sure whether or not there is such a restriction before you can know for sure whether or not that community can have something like that.
Can you give a few examples of circumstances that would be considered conflict of interest for board members?
Well, a conflict of interest of a board member is a problem if the board member has a personal financial stake in the issue that's being decided. If the board member is a part owner of a business that is submitting a bid to do work for the association, there's an inherent conflict of interest in that board member making a decision. The law requires the board member to make full disclosure to the board of their involvement in such an endeavor. And once there's been the full disclosure, that board member would need to abstain from the vote on issues that would affect their own personal financial interest. That's the main conflict of interest issue within community associations, is the financial nature of a personal gain.
Last question before we go to your schedule coming up. This is an HOA with no quorum at the annual meeting. Does the budget simply roll over to the next year if there's no changes allowed?
Well, annual meeting is typically not a budget issue. It's for the election of directors. Annual meeting of the members is where they typically will elect the directors. And for HOAs in Florida, unless there's a lower number in the governing documents, the quorum number is 30%. If you don't get the 30% and there isn't a lower number in your documents, the board, if they're willing to continue to serve, would roll over for another term. And the board would adopt a budget in the normal course of the board's business.
You've got a busy month in July.
We do.
So one of the great things about K. Bender Rimbaum is you offer so many educational classes at no charge. And it seems like you've got many of your staff members always working these classes. What do you have for July?
Starting on July the 8th, most of these are going to be on Zoom. At 11 o'clock to 1 p.m., we have HOA meetings, notice requirements, participation, and elections being presented by Kirsten Hens out of our Tampa office. There will be continuing educations for CAMs and HOA board members. There are credits for that. On July the 10th, at the South County Center in Delray Beach from 9 a.m. to 4 p.m. This is the CAI Gold Coast Day of Education. During the course of the day, Jeff Rumbaum will present the legal update for managers that need credits before September 30th. That's legal update for changes that were adopted during the legislative session in 2025. The deadline for managers getting those credits is September 30th. There will be 2 continuing education units for licensed CAMs at that event. I don't have a specific time for that, but you can check on our website at kbrlegal.com for the time of that particular presentation. On July the 16th, and certainly for Tampa Bay listeners, at 10 a.m. to 11:30, brunch and learn with Kirsten Hentz at the Sarasota Chamber of Commerce, updating governing documents. There is some continuing education for CAMs and HOA board members as well. On July 17th, a Zoom from 12 p.m. to 4 p.m. This is a big one, the 4-hour condominium board member certification course will be presented by attorney Andrew Black from Pompano Beach and Danielle Brennan from our Palm Beach Gardens office. So be sure to budget enough time for that one, 4 hours. Wow. July the 21st, a Zoom from 11 to 12:15. HOA record keeping and records access. Kirsten Hentz from Tampa will be presenting. CEUs for CAMs and HOA board members will be provided in that one as well. On July the 29th, by Zoom, 11 o'clock to 12:30 p.m., HOA financial literacy and transparency. Kirsten Hentz from Tampa will present again. CEUs for CAMs and HOA board members will be included on that presentation. And last, on July the 30th at 11 a.m. to 12:15 p.m. by Zoom, elections for community associations. Peter Mullengarden from our Palm Beach Gardens office will present. And there again, CEU for CAMs and HOA board members at that event. Now, for all of these, go to our website, kbrlegal.com, click on the calendar, identify the event you're interested in participating in, because you're going to have to register in order to get the Zoom credentials so you can log into the event.
We just had someone ask, before we go to break, can you give out your phone number again?
You can reach us at 800-974-0680. You can reach any of the offices by calling that number. You can write us at info@kbrlegal.com. Or you can go to the website, and there's a contact box on the first page. You just fill out the information, and someone will get back to you within a day or so.
Wonderful. We're going to go to a quick break. We'll be right back with attorney Robert K. Bender Rimbaum. We'll be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your host, Steve-O, and his expert guests.
We're back. We're here with attorney Robert K. Bender Rimbaum. We do this show the first Thursday of the month at 5 o'clock Eastern Time. We also do a Tampa show the last Tuesday of the month, same time, 5 p.m. Eastern Time. And then we have our Orlando show the last Thursday of the month, again at 5 o'clock. Let's get back to the questions. This is Sal and Aventura. And we've had a lot of questions about electronic cameras. Does the electronic camera have to have signage that their voice and other video are being recorded?
If you're recording audio, it's necessary there be advance notice to the whoever's going to be around. We don't recommend that cameras placed on the common elements be recording audio because Florida requires two-party consent. You can do the video without an issue. It's good to provide signs that there will be video surveillance taking place on the common elements. We do not recommend that include audio.
This is from Greg in Deerfield. He's a condo. If there is no bylaw establishing a timeline when a visitor becomes a resident, triggering an application and approval to live in a condo, what determines a change of status?
That if there's nothing in the documents that identifies that, we have had clients, if they have sufficient documentary authority in the documents for the board to create a rule that would trigger the time frame of occupancy by someone who's not a resident before they would be considered a resident. It's preferred that there be something within the declaration itself, as that creates a higher level of enforceability under the law and less possibility of a successful legal challenge as a board-made rule might create, because of the requirement that the board-made rule cannot be in conflict with what the governing documents otherwise provide. When the documents are silent on an issue, the presumption is that the issue is not restricted, and for the board to adopt a rule that creates such a restriction can subject the restriction to a successful legal challenge, which the board would certainly prefer not to have. So in that instance, we would suggest, if possible, the board present an amendment to the owners to the declaration to provide for those specific timeframes, and then that becomes basically part of the constitution of the community.
We get a lot of questions about handicap parking. This is one they just want to know, do I go to the board to try to get more handicap parking or to the city?
Well, the city really doesn't have anything to do with it. The community is set up as it's set up, and there's been governmental approval of a site plan that contains X number of handicap parking spaces where they're located. If a resident needs a reasonable accommodation under the Fair Housing Act to have some form of handicap parking at a location other than where they're able to currently park, and has sufficient medical support for that request, it's possible that that owner can have some alterations made to the parking configuration to accommodate that request if it's reasonable under the circumstances at that particular community. In general terms, handicap parking is not supposed to be for residents, it's supposed to be for guests. And residents would typically have assigned parking spaces elsewhere within the common areas. Again, if they have a special need that qualifies under the fair housing laws, then they might be able to work something out. Many communities just have open season on their handicap parking, which creates problems because some owners monopolize it and guests aren't able to access it when they come. It's generally recommended that the board make certain that there are rules in place clarify that these are restricted to outside use, not residential use, and enforced accordingly.
This is from TikTok. Oh, this is a local one. They want to know, does your firm, I'm trying to get our firm to bring you out to talk to the board members. Do you come out or do we come to you?
Both. If the board wants to come to us, our offices are available to hold meetings. If the board prefers us to come there, we'll do that. We also have many introductory meetings via Zoom. So any way that works for the board, we're certainly looking to accommodate.
Since we know they're listening, Robert, can you give out your phone number again?
Call us at 800-974-0680, or you can go right to us at info@kbrlegal.com. On our website, there's a contact box that you can fill out.
Okay. Do they ask for anybody in particular?
No, just identify where the community is located so we can match them up with the closest office to them.
Okay. This is from Jordan. He wants to know, what can a board do to entice those recently elected to an officer? We've had several elected members who want to be on the board but not an officer. This leaves us short officers in the future.
Well, it's important to recognize that officers and board members are two completely different things within a community association. Sometimes the same people hold both offices. Their functions are different. And sometimes the officers aren't board members at all. So you have to check your governing documents to see if there's a requirement that officers be board members. Many just require the president to be a board member and possibly the vice president so that if the president leaves and the vice president steps up, they'll both be board members. But you do want to check your bylaws, articles of incorporation to see whether that's a requirement or not. There's no legal way to force somebody to take on the role in an office, but in basic functional requirements, board members establish the policy of the community, of the association, and the officers carry out that policy on a day-to-day basis. Quite often people mistake officers acting in their officer capacity as board members acting in their board member capacity. As most of us know, that when a quorum of the board meets to conduct association business, that's considered a board meeting that requires advance notice to the community and allowing the owners to participate. There is no such requirement for officers to meet and discuss association business in their capacity as the officers of the association. There is a very subtle but distinct legal difference between those functions. So if you've got 3 out of 5 board members who are the officers of the association, and they're in the office doing their officer duties and talking to each other as they do it, many owners would say, hey, you're holding a board meeting and you have to post notice and let us attend. But that would be a mistake because that's not what they're doing. Unfortunately, you can't force somebody to do the job. Once they get elected to the board, they have to be willing. So I can't offer much more on that specific question.
This is from Mark. He said, I'm new to Florida, just moved here. I know this is hurricane season. Whose responsibility is it to let us know what we can and cannot do during hurricane season?
And what's the setting of this individual? Is he in a HOA or condo? And
Condo.
What does it mean what he can or cannot do? If you're in a condominium, you can reach out to management and ask if you didn't get a copy of the rules of the association when you acquired your unit. You should have gotten a complete set of governing documents, the declaration of condominium, the articles of incorporation, the bylaws, any amendments that have been adopted through the years, as well as the rules and regulation. There's typically specific provisions in the rules that deal with hurricane situations. If you're down by the water, there's usually evacuation potential when there's a storm that's nearby that you may have to follow. But you start with the building management on that.
Okay. Here, this is kind of a broad question. I'm curious. I just found your show. Why is it important to have a law firm such as yours to represent our association?
Well, that is a good question. The area that we're dealing with in community association law is one that has been evolving over many, many years, and it continues to evolve each year. 2026 was a little unusual in that there was very little done by the legislature in tweaking any of the community association statutes. There was some changes made to Chapter 617 this year, which is the Not-for-Profit Corporate Act, and that applies to pretty much the vast majority of community associations in Florida. But the changes were not of a nature that's going to really make much difference to the operation generally of community associations.
Carrie in Fort Lauderdale wants, for a board meeting, can you have a Zoom only meeting, or do you also have to provide an in-person meeting as well?
Changes made last year now require, if you're doing a Zoom meeting, that you have to have a physical location for owners to attend and participate. We had always recommended that as soon as Zoom started 5-6 years ago, that there be a place within the community, because a lot of times there are owners who don't use the internet or who might not be comfortable or able. In that case, they need to have a physical access point. Now it's a requirement.
This is from Karen in Delray Beach. She's an HOA. The board passed a special assessment for clubhouse repairs. An owner believes that governing documents require an owner vote. The board disagrees. What are the owner's options?
Well, the issue on whether or not owners vote on something will depend upon a couple of factors. First off, what is it that is being done by this alteration? And you said this was an HOA or a condo?
Yeah, HOA.
HOA. HOA has no statute that provides for an owner vote requirement on alterations to the common areas. So then you have to look to your specific governing documents to see if there is any limitations on what the board can do. Sometimes there is a requirement that if it's a capital improvement, in other words, you're going to put something in that wasn't there before. You're going to create a playground in an area that was a grassy area before. A capital improvement of that nature may require a vote of the owners if the documents so state. And if there's no provision in the documents that limits the ability of the board to undertake capital improvements without an owner vote, then the board can make that decision on its own. So for the owner asking this question, you'll probably want to consult with an attorney who understands community association law to go through your governing documents with you and make a determination whether or not what the board is doing is open to a legal challenge or not.
This is from the chat line. Can the fining committee set the amount of a fine, or must the fine be set by the board and then approved by the fining committee?
Under the statutes, the function of the fining committee is to either approve or disapprove the fine that was imposed by the board. So the board sets the parameters of what it's going to fine, how much it's going to fine, and when the fine's going to happen. they have to have a hearing before the finding committee where the board presents its position, the owner can present his or her position, and the committee's function is to say yes or no. That's it. They're not there to negotiate. They're not there to try and maybe reach a lower number. They just say yes or no to what the board is proposing.
This is in the chat line. So that we skipped a question regarding board members in a chat giving directions to the property manager and whether or not that constitutes a quorum or even a meeting.
Well, it wouldn't constitute a meeting, but again, you have to think of it from the perspective of what we talked about a few minutes ago, whether they're acting in their board capacity or whether they're acting in their officer capacity. Quite often, it's the officer capacity that deals directly with management and gives the instructions as to what they should be doing. The key is, are they making decisions at that gathering? That's what constitutes conducting association business, since the statute doesn't provide a more specific definition, and there's been no Florida appellate court case that has created a more specific definition. So there has to be a motion, a second, a resolution, and a vote in order for that to be a association business being conducted. If the board member or officer is just giving instruction to the property manager to do this or that, that's just carrying out the officer function of the policy previously adopted by the board. So there's no legal issue of a quorum or a meeting that hasn't been properly undertaken.
I'm going to get this gentleman's question in, even though it comes up all the time. Ronald in Boca, just the fact that he said he loves your show. Our staff watches it every month. Can our annual meeting be done by Zoom? I know that's asked a lot.
Well, yes, it can be. And the board would have to provide the appropriate notice for that and provide a physical location for those who do not want to use the Zoom to attend in person and be able to participate.
Cecil in Boynton wants to know, what does it mean to ratify a decision of a board outside the meeting?
Well, quite often issues come up in between meetings that are of such a nature that a decision has to be made in order to protect the community property and avoid the potential of greater damage by not taking action, and no time to convene a meeting to make a decision. So the law allows for the board to, at a later date, consider the issue that was previously decided outside of a meeting and approve it, which is the ratification of that action, which now has made it appropriately adopted by the board, even though it was after the fact.
You know what? Your show goes by, I say this all the time, so fast. You know, I wish we could have gotten every one of the questions in, but you will be back with us again the first Thursday of the month in August. Can't believe time's going by so fast. For those, Robert, that are not viewing the show but listening to the show, can you give them your phone number and website again?
Sure. You can call us at 800-974-0680. That would be for any of our 4 offices. You can write to us at info@kbrlegal.com, or you can go to our website at kbrlegal.com and you can fill out a contact box on the first page. And while you're on the site, you can click on resources and you can find a large number of topical articles, be it through Legal Morsels or Rembaum's Association Roundup, which is made available to the public at no charge. And you can search for whatever topic might interest you at the time. We do update those fairly regularly.
Robert, have a wonderful 4th of July weekend.
To you and all the listeners as well. Safety first.
Yes. We'll see you again next month, the first Thursday of the month, 5 o'clock Eastern. Thank you so much, Robert. I know this is such an important area. People have so many questions. I've learned that over the years with the show. Thank you so much for taking the time.
All righty. Take care, everyone.
Thank you. That's attorney Robert K. Bender Rimbaum. That's going to do it for us today. We'll be back again with you tomorrow at 2 o'clock Eastern time. We'll see you then.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.